take the roll, please? I'll give a minute or two for the those coming in to get to their desks. I believe that is all that's here. Hard for me to tell, but we have 19 in attendance. I did get a couple of calls today. Supervisor Clark, Supervisor Kohlmeyer are both going to be late at best. Others I'm not sure, but Kubicki and Haas are both excused. So we'll see what transpires the rest of the evening. So we are on the committee of the whole. First order of business is citizen comments. Anyone wishing to address the board? And I would, Mr. Olson, if you'll hold on for 1 minute, we'll see if there's any other citizen comments, and then we'll go into your presentation. Any citizen comments? Anyone wishing to address the board? Seeing none, citizen comments are closed. All right. Before us this evening is the discussion about an extension to the intergovernmental agreement. I want to explain a couple of things as we get started here. On your desk before you is a resolution that you will see is in color. The red is comments that I have put into this resolution. The blue are additional comments that were put in here by Corporation Counsel. What I have done is modified the resolution from the previous extension related to this issue. And what I'm looking to accomplish this evening is a 30-day extension that essentially will give us time to understand the specifics and the dynamics of the casino application currently, so that we can craft the language for an appropriate extension, if you follow me. The city passed the resolution that granted a 30-day extension. There's some things they're looking to do. You'll see in the verbiage in the resolution before you, there's some specifics on what I think should be put in place. It was asked to me this evening if something beyond 30 days might make sense. I would only suggest this as we begin to debate it when the time comes. Given our county board schedule, our meeting dates, it may make sense to talk about something a little bit longer than 30 days. That will give us, as I was talking to Mr. Olson yesterday, sort of a hopscotch with the city and the county, their date, our date, the final end date. As long as the final end date, in my mind, extension is agreed to by both parties, and all the terms, parties I'm talking about, city and the county, are all the same, I don't know that it matters that we kind of hop over one another with this short-term extension. So with that, I'll throw it out, or I'll leave it at that so that I don't get into debate, as Corporation Counsel has cautioned me. And at this point, I'm going to start the committee of the whole discussion with a brief presentation from the casino group. Mr. Olson.
Well, good evening. Eric Olson, Project Director for the Kenosha Casino Project. Thank you all for coming in tonight on this special meeting and committee meeting. I'd like to introduce Bruce Pecor, who's on the tribal legislature and is also on the Kenosha Gaming Authority, and also Lori Oveen from the tribal. She's the chairman of the Kenosha Gaming Authority, and also is on the tribal legislature. So I'm going to let Lori do the presentation. If there's any questions, we're here to answer any and all questions you have. Thank you.
Good evening, and I wish to extend that we're very thankful that we can come before you tonight to give a presentation, and that you did a special meeting to allow us to come in and entertain this extension. My name is Lori Boveen, and I've been on the Menominee Tribal Legislature for entering my 9th and final year right now, and I've been part of this whole project since the beginning of 2003, when we first came in a long time ago and made presentations to both the city and the county. So we've been at this a long time, and I was really hoping that by the time my term would be up, we would really know one way or the other where we were going to be. I'm still hoping for that, but it's been a long time, and we just won't know for sure. But where we're at is the tribe had, as everyone knows, filed an application for a project here in Kenosha. We have different agreements. We have the intergovernmental agreement with the city and the county, between the authority and with the tribe. We have our option agreement with Dairyland, and we had surpassed both of those dates back in 2009 just because of the duration of time that it has taken for the project to be reviewed by the federal government. Back in 2007, which we just learned earlier last year when we filed our litigation against the Department of Interior, the Midwest Regional Office had recommended approval of the project to the central office in DC, which then would make a review. Basically what happened is, under the previous administration, they had done a procedure called a guidance memorandum, and basically had denied quite a few applications that tribes had in to the Department of Interior. Our tribe was one of the last ones to actually get denied. January 2009, I believe, is when we actually received our denial. And at that point, the tribe had, after reviewing everything, decided that it was in our best interest that we actually file litigation against the Department of Interior for that action based on their reasoning. And so we've been in litigation from that time. And so because of that, we went past the timeline on both the IGA, the original IGA, I think was at the end of 2009, December 31st, 2009, as well as the option agreement on the track. So what we've done is we asked for extensions because of where we were with the litigation process. So we got the first extension and then thought that we would kind of know where we were at. But litigation with the federal government is just time-consuming, a very overwhelming process, and it seems like it's almost a forever waiting game to get any type of action out of the system. So we had, you have to meet all these timelines, and I am not a legal person, so I probably will mistake some of those, but there's filings, or different filings, briefings that you have to do. So this January, and if I back up last year, we had submitted a motion to add additional evidence into the record that had been discovered once we had reviewed the administrative record. The federal judge basically did approve the tribe's motion to add that additional information into the record in November of 2010. The other part that we had asked was to depose certain federal officials that had taken action on the application. We were denied that, but it was left open that as the case moves on, he may look at that at a later date. So after that time frame, the next time frame that the tribe had to meet was we submitted a motion for summary judgment, and that was due to the courts by the end of January of this year, 2011. The Department of Interior then had 45 days to file their briefs, which would have taken us to March 15th. They had a change in attorneys at the solicitor's office and had asked for a 30-day extension to do their filing on the motion for summary judgment. That was granted, so their new time frame is now April 15th to get their filing in. My understanding that the overall window of all the different things that you can file for, and this is where I'm not good at this, it's my understanding that everything has to be done from all sides by the end of May. So once that, and that's I guess, if as long as there's another time frame, and I believe that the next time frame is the end of May. So once that time frame closes, it's in the judge's hands to make a decision. There is no set time frame that they have to make decisions in these cases, and this is an administrative review process. So there's no time frame that the judge has to render a decision. But of course, we've asked for an expedited review because we've been at this for so long, and we really need to know one way or the other where we're at with this project. The tribe feels that we have a very strong case, and we feel and are confident that we will be successful on the litigation end of this. But what's happened in the meantime, again, is the extension on both the track and the extension on the intergovernmental agreement, again, is nearing expiration. So the first decision that the tribe had to make was if they were going to approach and ask for another extension on the option agreement for the track. We did that, and we just learned of that, that we were able to do that maybe about a month ago. So that's where the timing is kind of off, and I apologize for that. We would like to give as much advance notice as we can in these matters so that you have full time to make your decisions. Our windows just haven't allowed us to have the best time frames available. So we were able to get the extension. So at the point where we got the extension, that's when the letters had went out from the tribal chairman's office asking for extensions on the intergovernmental agreement to run basically for the same length again as the track. So right now we have our option extension goes until June 30th of 2011. So hence that's the 90-day window that we were looking at. From the tribal side, the tribal legislature has motioned to do a 90-day extension. Last week we did meet with the city, and at the end of that meeting, the city's decision was to do a 30-day, and in that 30 days they want to sit down and try to work out some additional language within the document that will allow for a time period that will specifically allow us to get to negotiations, if that's what we choose to, on all parts at a certain time frame in time based on some triggers that will happen with the application. We have agreed to that, and we understand, we know that this is six years old since we've all worked on it and come with these agreements, and the same thing for us. Our business plan, everything that we've worked on, we know is outdated. But for us, we have chosen that until we have a substantial movement by winning our litigation, settling our litigation, getting it to the point where we know it's going to move at the federal level so it gets back down to the state level, we would be wasting our time. We would be wasting our resources to try to guess again at relooking at our whole plans until we have substantial movement to know that this project is going to move forward. So we know that all those things have to be done, and we've been kind of chomping at the bit on it as well. But until we see where our litigation's going, if we can settle, or if we're gonna just leave it in the hands of the courts. We've decided not to try to refresh in numbers when it may be another time period before we actually see anything, and we would then have to refresh and everything again. So we understand the need to review and look at this outdated information, because on our side we have the same thing going on with all the plans that we had. But we're just trying to keep this project moving. The tribe has you know, you guys all know our story. Large, poor tribe, don't have a lot of resources to be put into litigation, but we felt that this was what we had to do for our membership and for our partners and for the relationships that we've built with the city and the county. This is a very important project to a lot of us, and we continue to battle it out. And so to this point, we spent quite a bit of resources on the litigation, and it's basically, it's so close, but yet it's so far away. So it seems like we take a couple steps forward and then we get backed up against the wall again. So it's been a very frustrating process. But we're still there, and we still believe in this project, and we'll continue to do the battle until we win or we lose. And that's kind of where we're at with this. So the extension to the both the option agreement and to the intergovernmental agreement are key in the documents that we filed in our application that is in front of the litigation. So if the current documents, that's what they review. That's what the regional office recommended. So it's our goal to basically keep that intact as much as possible to get through the process. Am I forgetting anything? Okay. So I hope that answered some of where we're at, why we're at, where we're at, and just the hope that you'll continue to want to be our partner and help move forward with us as we continue to pursue and do everything on the litigation side that we're currently involved in. You know, we're hoping that we'll know by the end of the year, by the end of summer. We'd like to know by the end of summer, but we're really hoping by the end of the year we know one way or the other where this project's sitting through this process of litigation. So with that, if there's any specific questions that you have, I'm more than willing to try to answer those.
Thank you. I trust there'll be some questions that will come up. My intention here is to open the floor to debate in just a moment, and if there are questions that we need to have directed to you or your group, we'll certainly do that. Anything to add from the other two gentlemen? We're good? All right, let me just point out one additional thing as well. Certainly tonight's discussion germane to the topic will be specifics, or could be specifics, of the intergovernmental agreement that are in place currently. Again, I say that it certainly is germane. If someone wanted to bring that up, it would be my hope that we don't get into the specifics of the intergovernmental agreement this evening. This extension is going to get us to a point where that will become a discussion point in the appropriate setting, the appropriate venue. If that's where you want to go, certainly I will allow the discussion. And then finally, I want to point out one more time, those who came into the room late, and also to the body in front of you, the reason this resolution is on your desk this evening is, as you know, this meeting was scheduled last Tuesday. So the first opportunity I had to get to drafting something was this weekend. Corporation Counsel got back to me yesterday with what he's added in blue, and you have it before you. It is a modification of the document that we've previously approved. So I trust that we can adequately review it this evening as we talk, and I guess the timing is what the timing is. So with that, I will open the floor to discussion. Supervisor Jeffrey Gintz.
Thank you, Mr. Chairman. Through the chair to the presenter, is there any other litigation against the DOI that you're aware of from any other tribes, or is that got denied?
Our tribe's the only tribe that is pursuing litigation at this time.
Okay. And I guess, you know, not wanting to go on about it, but do you think that the difference in what's changed recently is the, you know, just the evidence that you brought in November? Because I don't necessarily see that much movement. You know, is the change, the reason you think this may go because of that?
We felt we had a strong case prior to adding the briefing to supplement the record, and we feel with the supplement that it only made our case stronger.
Okay. To the chairman, I'm just reviewing this briefly. Are you asking for a 30-day or a 90-day? Is that,
The resolution is currently drafted as a 30-day extension.
Right.
The 90-day in here references the fact that the tribe requested,
Okay,
sought
okay.
a 90-day extension.
Okay. Personally, I think that we probably should do the 90-day, because I don't think that anything's going to change in 30 days. I don't think they're going to be able to provide us any new information, and I don't think their case will change. And as long as we could tie ourselves into the track, which gave them a 90-day, I would think that have them come back to us with an update on their case and any modification to the plans at that point might be the way to go rather than a 30-day. Because obviously things have changed, plans, economic conditions, and such.
Supervisor Gintz, I'm going to cut you off for 1 second. Corporation Counsel, do we need a motion on this resolution from the floor before we can discuss it, or are we able to discuss the topic with a motion to the full board? All right, with that, I'm going to ask for a motion from the floor on the resolution before you. Motion made by Vice Chairman Eckernes, seconded by Supervisor Michael. Thank you. Supervisor Gens. Thank you, Vice Chairman.
Always cutting me off.
It was a setup, as you know.
Well, I think I'm just about done anyway. That'll just open my debate. I just don't see the need. We're going to have to have another special meeting prior to the 30 days to say nothing's really happened, and we want, you know, more information that we're not going to be able to get. So I would think, listening to the presentation and the fact that they have till the end of May or whatever to respond, and the judge needs a little time to look at it, I would think the 90 days would be a better way to get information back to us. Thank you.
Thank you. Supervisor Rose.
Thank you, Mr. Chairman. I think this project is dead, and the presenters here just aren't willing to recognize it. And I think the sooner that we as a board and a community begin to recognize it, other plans will be made for this very valuable piece of property. The Greyhound Park is closed. That property certainly, I think, has a very bright future. It's on hold now for the obvious reasons that there's this litigation pending, the desire on the part of the Menominees to have a casino there. But 30 days or 90 days is not going to resolve this litigation, perhaps a year or 2 years. But if you begin to analyze these possible successes of this, I don't see any change in the position of the federal government if you probe here. Under the Obama administration, different than the Bush administration. Now, why do I say that? The application was rejected in 2009 under the Bush administration. This was one of the last acts of the then Secretary of the Department of Interior, Mr. Kempthorne. We were told, if you recall, that there would be a new day with the Obama administration, that our chances of success, or their chances of success, for a renewed application were very high. And here we are well into the Obama administration talking about the next election, and we have heard nothing about the possibility of approval by anyone at the Department of Interior, even though we have a new president, we have a new secretary, we have a new Solicitor General's office, and nothing has changed. The litigation was started when President Bush was in office. The attorneys there representing the government were all appointed by then President Bush. Now we have a new president. We have a new attorney general. We have a new solicitor general. We have new lawyers at the Department of the Interior. You would think that they would come in and concede. They have not. They're taking the very same position today that was taken under the Bush administration. No difference. So why am I here tonight thinking that another 30 days, another 90 days, another year, another 2 years will make any difference? I see no change in the position of the federal government today than there was under the Bush administration, and none has been presented here tonight. Let's just assume for the sake of discussion here that they win their motion, they win or lose their motion for summary judgment. If they lose, they have much more litigation. All that means is that there's an issue of fact here, they're going to trial. That's all that means. And if they win the litigation at the summary judgment level, all that really means is that there was a procedural error at the Department of the Interior in the consideration of the application. It doesn't mean that the application is going to be granted. So I don't think we need to be deceived here tonight that if they win the summary judgment motion, there's going to be a casino here in Kenosha. Not so. All it means is that there was an error in the administrative process at the Department of the Interior. So the application goes back. Again, why am I to think now that here in 2011 there's going to be a change in the Department of the Interior's position if they win their motion for summary judgment after the lawyers for the government have opposed their motion for summary judgment? I would think that if the government was in support of the nominee's application, they wouldn't be opposing the motion from a summary judgment. They would go into court and concede it, and they would have their application back at the Department of Interior under consideration, and none of that has taken place. So I think it's fanciful thinking here to suggest, as they have here tonight, that if they win that litigation, it's smooth sailing thereafter. There's a casino opening, I understand, that's in Des Plaines, Illinois. Why is that going to enhance the possibilities of a casino here in Kenosha, Wisconsin? Or are they going to take a regional viewpoint of this whole thing, with one casino drawing off another, we drawing off Milwaukee and they drawing off us, and the same with Illinois? So I see nothing here in the landscape here in southeastern Wisconsin or in northern Illinois which would enhance their position. And so what is the big downside here? The big downside here is that we postpone plans for that land, or the owners of that land postpone plans for it for some other use. Be a great industrial park, be a great extension of the industrial park of the city. It's adjacent to I-94, and I think that those are far more realistic options that should be looked at. And if we put aside this application here tonight, we can, and they can, begin to look realistically on what are we going to do with that land, and what are the owners of that land going to do, and what is the community going to encourage for that land in the future. Thank you.
Thank you, Supervisor Rose. Supervisor Michael.
Thank you, Mr. Chairman. Just a brief question regarding this resolution. When you drafted this resolution, does this mirror what the city of Kenosha did? I mean, is this basically the same thing, or is there?
No, but I would let Corporation Counsel address that if he'd like, in terms of his communication with the city of Kenosha.
I have a copy of the resolution that was passed by the city council. I can go over it for you real quick. I'll just go through the therefore clause. Parties agree as follows. Term of the IGA is extended, and Section 3 of the agreement is amended. The intergovernmental agreement shall remain in effect for so long as the trust land exists, unless otherwise terminated by mutual written consent of the tribe, the authority of the city and the county. It shall terminate if the tribe and the authority are unsuccessful in securing approvals necessary to implement the tribe and the authority's proposal to develop and operate the facility by April 30th, 2011. So they got a 30-day, basically a 30-day extension. The terms of this second extension shall become effective upon approval of the governing bodies of the city, the county, the tribe, and the authority, and execution by the appropriate officers. Nothing in this second extension is meant to amend, or does it amend, any provisions of the IGA other than Section 3 above. All other provisions are to remain in effect. The tribe, the authority, the city, and county each represent and warrant that each has performed all acts precedent to adoption, including but not limited to matters of procedure and notice, and each has the full power to execute and perform its obligations, and that the representative executing this extension on behalf of the party is duly and fully authorized to execute and deliver this extension. The extension may be executed in several counterparts. The authority shall submit this second extension to the Secretary of the Interior, and some other boilerplate language.
But Frank, with this, the 30 days, is it a direct expiration, or is there anything that would trigger an extension?
Well, let me read it again. It shall remain in effect so long as the federal trust land exists, unless otherwise terminated by mutual written consent of all of the parties. It shall terminate if the tribe and the authority are unsuccessful in securing the approvals necessary to implement the proposal and operate by the facility by April 30th, 2011. So it's a 30-day extension. There's nothing that would preclude the city from coming back prior to April 30th, 2011 and doing another extension, if that's your question.
Right.
If I could answer that further, my understanding is the city is intending to do exactly what I talked about initially, which is to outline the two specific sentences they want. I say specific, they're non-specific, but apparently there's two. They don't have the verbiage for them as yet.
Okay.
And they'll do that before the 30th and then extend beyond that.
Okay.
Is that correct, Mr. Olson, as you understand it?
Well, I mean, there's been a lot of work done by the county board, the city council for this. I think it's appropriate we pass this resolution. I disagree with Supervisor Rose and his connotations regarding this property. I haven't heard anybody knocking on the door demanding this property to be purchased. We know what the economic times are currently. Heck, if Chrysler called up and said, Kenosha County, we want to build in this property, or Marriott, or somebody said, we want to build a complex, I'd be the first one to say, hey, you know what, tribe, thanks for trying to do something, to put something in our community. But I haven't heard that. I think it's time. We have nothing to lose to continue, give them some extra time and see what happens. I think it's appropriate. We've done a lot of work, and if it goes through, it could be very economic. It could be very good for the economics of this community. Thank you.
Thank you. Supervisor Holman.
Thank you, Mr. Chairman. Before I dig in with my questions and remarks, I want to apologize for my tardiness. I just came back from the UW Extension Lobby Day in Madison and was a little too comfortable in my home when I checked my email and realized I needed to be here, so I apologize for my tardiness. I guess I have, first off, a question to the presenters. I know there's a substantial portion that I missed. That question would be, through the chair, to the presenters. If the Office of Indian Gaming or the Department of the Interior were to make a policy change, does that change the status of your application, or is this strictly about pursuing litigation?
Currently, as it sits right now, anything that they would do because of our litigation, the litigation keeps us at where we were at the point where they denied. They have talked about policy change, but they haven't actually provided any policy at this point. But the litigation is based on the rules or the law that was in place at the time when we filed our application. And that's what we're asking for the review to be done at the point where we're successful in litigation.
Thank you. I remember perhaps it was maybe a year or two ago, this issue was given to the Legislative Committee, and we tried to dig in as much as we could. And we had a great deal of discussion about a number of things pertaining to this. But I think the thing that is the most pertinent was the question of what is the federal government going to do? There were calls that were placed to the regional office of the Bureau of Indian Affairs, and basically they said, we approved everything, we think it's fine, we sent it off to Washington. And so basically the phone call was then made to Washington, to the Bureau of Indian Affairs and the Office of Gaming, and basically the question was posed, where are you on this? What is it that you intend to do? And the response that came back was essentially, the Bush administration made some last-minute changes. We are conducting an analysis and a review of those changes. We also are using 30 minutes a week on Thursdays to brief the Secretary of the Interior about all of the components to IGRA, the Indian Gaming and Regulatory Act. And that was basically where they were. That was the end of it. I called them late last week to say, are there any new developments? Has anything else come to light that we need to be aware of? What they did say was that the Office of Indian Gaming had sat down with tribal leaders across the United States to talk about what their concerns were as it pertains to Indian gaming, and then an executive summary of those concerns as well as potential action items was prepared and given to the Secretary of the Department of the Interior. I asked if I could have that executive summary. They said no. I questioned whether or not I should pursue it further according to our discussion tonight, but I left it alone. So I don't know what's in that executive summary. Other than the fact that I did inquire as to whether or not intergovernmental agreements were raised as an issue, the response I got back was yes. I said, are there going to be any changes made in policy, in administrative rules anytime in the near future? They said we can expect to see some sort of statement and or policy change in a month to 2 months. So essentially that leaves us basically where we are, but we do know that the department is apparently going to make some sort of movement in some direction. Now, the other thing I also want to bring up very quickly, and this pertains to this, is the Department of the Interior, and I think this addresses perhaps some of Supervisor Rose's concerns as to why this might have seemed dead, is that department has been plagued by very, 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 very serious problems. You had the previous secretary who spent hundreds of thousands of dollars remodeling the bathroom. You had regulators that were having drug and sexual relationships with the lobbyists that they were supposed to be regulating. This is also the same office, or rather department, that had to deal with the BP oil spill. They have had one catastrophe after another that they have had to deal with. And I think particularly when it comes to the issue of Indian gaming, it seems like this is an area where federal regulation and law, in terms of the secretary in particular, is directly involved in terms of the outcome. And so I think particularly the delay that we have seen has been because there are other things going on in the Department of the Interior that have taken center stage over the last several months. Thank you.
Sounds to me like they may be spending 30 minutes on the wrong issues. If not the need to spend much more. To your point, we did have the discussion, and I don't know if you're referring to our discussion about, or at least email, about obtaining this document for tonight's meeting. I think the document you're referencing is one that certainly is important to obtain should there be a longer extension and a discussion about reopening or renegotiating or looking at this 6-year-old document all over again. Clearly, those details will be important to have at that point in time. Was it pertinent to tonight's discussion? I suppose on some level it could have been, but you know, I scheduled the next meeting for 7 o'clock, so I'm not convinced that that would have been the best use of time. So I appreciate your diligence. Supervisor Elverman.
Thank you, Mr. Chairman. I'll be very brief. In 2005, when we went through all of this, I spent as much time as anybody on the IGA. One thing I know for sure is that it's the most important document to their application. If there isn't an IGA in place, the application's going to go nowhere. Personally, I feel 90 days is nothing in government time. We should go that stretch of time. To do 30, I guess tonight would be fine if we want to take another look at it, have another special meeting, but I see no reason to not to go 90 this evening. The city can have another meeting, but we want to be on board with this. We were on board with it initially. We put a lot of time into it, a lot of effort. The people in the community were behind it back then by a pretty good percentage. I think we had 2 supervisory districts that voted against the referendums. At that point, Kenosha County was booming and unemployment was at 4.7%. We're at 10.1, I believe the paper said this morning. I don't believe the electorate of Kenosha County would change dramatically. I think it would be just the opposite. We would have a higher percentage voting or wanting us to take a shot at this for 90 days for 3,000 jobs and a $1 billion project on that piece of property. So we have a chance. We take 90 days and take a chance. It's not a big move, in my opinion. So I would hope that when we end this discussion that we do the 90-day extension. Thank you.
Thank you. Supervisor Ron Frederick.
Supervisor Rose suggested that this issue is never going to happen. The question I have, I know we have an agreement that gives us revenues, and I don't know exactly what all the details are, but what would happen just at the sake that the county did not extend the agreement? The property's in the city, right? Okay, so what if the county didn't I'm not saying I am, but what if the county didn't extend the agreement? Would the city agreement still be in effect?
The agreement that was part of the application had 4 partners: the city, the county, the gaming authority, and the tribe. So all four partners have to be on board.
So you need them all, okay.
Yes.
Okay. That's all. I agree with the 90 days.
All right, I'm going to remind this board that the only way you get something you agree with is to make a motion. Supervisor Singer.
Thank you, Chairman. I just had a question, too, from the presenter. My question is in the Dairyland extension agreement, that in order to lock up the property, was there any monetary remuneration for that?
The extension has had monetary, there's been monetary things with the extension for a while. So yes, there is a monthly fee that goes along with that extension.
Okay. I know the tribe has put a lot of money into the litigation itself, too. Probably massive amounts of dollars, knowing how much lawyers cost.
You would be correct.
No offense to Supervisor Rose. But I think that brings up a point, and I think that needs to be brought out at some point. We, as a county, do incur costs every time these extensions come around. Private businesses end up getting extension money. We don't get extension money. We incur costs. I don't know. It's something to be aware of, I think, because rather than it just being a cost. Now,
Are you referencing the county incurring costs?
Yes.
Okay, that's addressed on page 2, number 4.
Okay.
that should we go to a negotiation or renegotiation.
Because I think that's important, that
county-
we do get reimbursed for those expenses. But I am in favor of, I do agree with Supervisor Rose, that this May thing just may not be, it may be the last thread that, for them, and, you know, but his point is, you know, why are we wasting our time on this? I don't think we're wasting our time on it, but I think that the electorate told us that this is what they wanted. That's why we voted for it in the first place. That's why I voted for it in the first place. And I would rather see it die on its own than for us as a county to come out and kill it, okay? We don't want to be the ones that are going to be killing this politically or anything, or economically for our county. Like Supervisor Elverman had indicated, you know, we're in a lot different situation than we were 6 years ago. You know, we may have wanted it 6 years ago. Well, we need it now, probably more than ever, if we ever needed it. I have always said that there's with a casino, there's always going to be expenses and things that we may take on a social level. But the bottom line is that it was voted on, and our electorate wanted it. Especially now, given that state funding is being extremely scarce regarding our budgets, the county budgets, the city budgets, the shared revenues, and also the schools. I think it's important that we look at all revenue sources and not just to dismiss it. I'm in support of the 90 days. So I'd like to make a motion that we change it from 30 days to 90 days.
Supervisor Singer made a motion to amend the resolution to a 90-day extension in lieu of 30, seconded by Supervisor Eckerness. I'm sorry, Supervisor Elverman. So I will be, is that all, Supervisor?
I just want to say that I agree with the 90 days, and that's why I'm making the motion. I think it is, as it was quoted in government time, you know, we can still negotiate it. It's still in here to renegotiate and do all those things. That doesn't mean, you know, but we as a body don't have to come back and be on top of it within the next two or have a special meeting and at the end of April again like this. We can do it in our regular course of business, and I think that's more important than upsetting the apple cart right now for us, and also upsetting the cart for the tribe. I think it's a reasonable thing to ask, and the city may do what they do, but we may do what we want to do. So, thank you.
Thank you. What's your point?
A motion on the floor? Is this just a friendly amendment to?
It's not friendly. It was a motion to amend from 30 to 90, and it was seconded by Supervisor Eckerness. So it was a motion.
So that just wipes out the first one?
It just amends the first one.
Okay, all right.
And I will be flexible on a discussion. I know it should be on the amendment, but I'm going to allow the discussion on the entire topic. Supervisor Rose.
Thank you. If I thought there was a realistic chance of casino here development as described many times within a period of 90 days, I would say let's support it. But I do think we're wasting our time here this evening by considering this. We meet at 6 o'clock. We talk about this. There are many other more important issues that we don't meet at 6 o'clock in special session or hold special meetings to review. What I think is a pie-in-the-sky proposal at this point in time. And when I hear, well, there's nobody else out there clamoring for this piece of property owned by Dairyland Park, that's true. There isn't anybody going to be clamoring for it or attempting to buy it when there's an option that they are paying for every month. It'd be interesting to know how much they're paying for this option every month. But nobody else is going to be seeking that piece of property with that option there. Nobody else is going to be interfering with those contract rights. And the community and the owners of that park aren't going to be looking at other options either. We need to be concentrating our time on developing the kind of industries that we need here, drawing the people into the community who have higher incomes and better educations, instead of tilting at these kinds of windmills. 30 days isn't enough, 90 days isn't enough. We're talking here about years of litigation, because their success in federal court is not going to be success at the Department of Interior. One of the most significant statements that the representative just made was that there has been talk about policy changes at the department level from those policies that were enunciated by the Bush administration through the Secretary of the Department, namely that they don't have the casino so far away from the tribal reservation itself. There's been talk of change, but the point of the matter is no change. Because this is a very, very hot topic. There are also always issues in every administration which are going to draw the attention away from the agenda, be it the BP disaster or something else. But the fact of the matter is that there's no policy changes, and to delude ourselves into thinking that we give them 90 days and we've gotten somewhere and we've done something for the community is, I think, just doing a disservice to the community. Let's move on. Let's start making other plans, other more realistic plans for this, and cut the cord here once and for all on a proposition that isn't going to come to fruition this year, next year, or the next year. And when it is suggested here this evening, let it die on its own, let's not be a part of it. It has died on its own. We just don't realize it.
Thank you, Supervisor Rose. Supervisor Gable.
Question, with a 90-day extension, do we get to look at the IGA, open it up and make adjustments?
I'm going to try to make this clear again, that whether you do a 30-day extension today or a 90-day extension today, you'll be coming back looking at a longer-term extension with specifics tied to it. And we may go 90 days tonight if this passes. It's conceivable we'll be back here in 45 days to vote on the extension with the specifics tied to it that are an attempt to be outlined here in this resolution. So, yes.
Okay, then I guess I'll support the 90 days. I mean, this is jobs in Kenosha, and God knows we need them.
Thank you. Supervisor Noble.
I'd like to get an opinion from Corporation Council on the 90 or the 30 with regards to the fact that the city did 30, us considering 90. I just want the Corporation Council's opinion on 30 or 90, because he knows more about what the city's done than I certainly do.
I don't think it will have any significant impact if you go to 90 and they stay at 30. I'm not sure that I agree with the representation made by the tribe earlier that if we did not do anything tonight, everything would die. It's been a long time since I've looked at this, but my recollection is that it is desirable to have both the city and the county support this project. That's your best case scenario, to show that the community is behind this and that there's not going to be any adverse impact on the community. If the land is located totally within the boundaries of the city, a question that would be raised in my mind is what would happen if the city went at this alone. Right now there's an agreement whereby the tribe will pay X number of dollars, net win calculated dollars, to the city, and of that amount 33% comes to the county. If in fact the Bureau of Indian Affairs says that city support is sufficient, county support isn't, that 100% would stay with the city. And I guess this comes around to your question, Supervisor Noble, what would happen if the city went 30 days and then did not, just did not renew their interest in this, and the county had another 60 days or another year or 2 years or whatever it was. You know, I don't know that that would kill the project at the level of the BIA. And maybe 100% of that net win would then come to the county. So there's reason for both the city and the county to come together on this and to stay with the original IGA, and to, if there's going to be some further negotiations on terms with all of the parties, that's one thing. But I think that, again, the best case scenario is for both the city and the county to be in support of it. I'm not sure if that answers all your question, but.
Well, the other part of it then, to just acknowledge from Corporation Council's perspective that if we went 90 days, the chairman of the board said we still would be either 30 or 90. We're going to be back here reviewing a longer-term contract. Would you agree with that then?
I would. It was my understanding that that was the intent, that we would take this time to go over the IGA with the board, which has a lot of new members on it, update them on what it provides. A question has come up with respect to amending provisions of it. I think that there are some, there may be some legal implications to that. I think that would give us time to research that. And I think that whether it's 30 days or 90 days or 60 days, whatever it is, I think basically what the chairman was looking for was some time to have a better presentation made to the full board with better facts and more facts in terms of the status of the case, the status of the environmental impact statements, and all of the things that have been pending out there and things that have changed. The role of the Mohicans, the ability to bond, all of these things are issues which the last time this came up for an extension, there was a list that I prepared, a list of questions that were submitted to the tribe, and they responded to that. I thought I had that with me tonight, but I don't. And I would suspect that within that 30 days or 90 days, that list would be resubmitted with any additional questions that board members may have.
So, and the tribe is asking for 90 initially? I mean, that's what they're asking for?
It's my understanding the tribe asked for 90.
Right. So if we grant 90, we would be most cooperative then?
Most cooperative?
Yeah.
One could certainly make that argument, I would suspect.
Yes, I would say.
I actually kind of agree, though, with Supervisor Elverman that, I mean, this is a 6-year process, and 90 days is a blink of an eye, and all the things that you said that have to be or will be done, more power to the city if they can do it in 30 days, but I think realistically it's going to take 90. So I'm going to support 90 when we get that to the vote.
Thank you. And to that point, the city will be back within 30 days to extend beyond that as well, as what was explained to me by then. So they're taking the same approach with what, at least on the surface tonight, appears to be a different time frame. Supervisor Decker.
Through the chair, how long is the agreement to Dairyland with the tribe for?
Are you asking what the extension on
Yes.
the option on the property is?
It's 90 days, so it's through June 30th
Good.
of this year.
And thank you, do we have since this has been stalled for 2 years, has the county or the city come up with a plan B if this does not come through?
Are you asking a plan B for the property in terms of development?
Yes.
Certainly the county has not come up with a plan B. I can't speak for the city. It would be my hope that they are entertaining, at least in discussion somewhere, of what to do with that property, but nothing that I'm aware of.
Okay, thank you.
Supervisor Hallman.
Thank you, Mr. Chairman. I apologize. In my questions and remarks earlier, I was looking for this and I didn't get to it in time. But through the chair to the representative from the tribe, to what extent does the governor have to get involved in this? I mean, would you have to go through the whole process again, or does our current governor have to honor the agreement of the previous governor and the Department of Administration?
We have a compact with the state of Wisconsin, so the current governor does honor that compact. Where the governor plays a role in this application is at the point where the Department of Interior approves the project, it comes to the governor for concurrence. So the governor would have to concur with the department's determination for approval. And if that didn't occur, then it doesn't happen.
So specifically, there is no agreement with the previous governor or the current governor specific to the development in Kenosha?
Through the chair to the representative from the tribe, is there any word as to what our governor's leanings might be, or his secretary of the Department of Administration?
The tribe is in the process of trying to get a meeting with the new governor.
Rumor has it he's leaned both ways in this issue, if that matters to you.
I think I have some friends that are that way. Mr. Chairman, I am supportive of the 90 days, particularly for two reasons. And the first is that this is the first that we have heard of a timetable from the Bureau of Indian Affairs. The second would be that this, to a certain extent, we have very limited control over this beyond just an intergovernmental agreement. So this has always been sort of a wait-and-see thing for us anyway. I do agree with another supervisor who said that there are other more important issues, things like jobs and education. I agree with that quite strongly, and there would be things that I would bring forward that I hope those individuals who feel that way would be very vocal in supporting. But I certainly don't think that this is a dead issue. If the BIA feels that they will issue something in 1 month to 2 months, then certainly we should hold out and see what they have to say. If it does turn out that it is a dead issue, then we have subpoena power, and it perhaps might be most entertaining to try to haul one of their representatives in here and understand why they're fondling a corpse. Thank you, Mr. Chairman.
Thank you. Supervisor Grady.
Thank you, Mr. Chairman. Before I start my remarks, I'd like to thank both the Chair and Corporation Counsel for putting some time and effort into this so we can all have a chance to review it. And further thanks for allowing the discussion to stray, shall we say, on the amendment and wrapping the whole issue into one. So thanks for the leniency there. But being the contrarian that I am in many cases, I will take support with the remarks that Supervisor Rose has made. And I'd like to just look at this whole thing in context of the present. When you look at our economy and disposable incomes and spending patterns and so forth, this is not an up economy. This is not a time when things are expanding and people have discretionary income to spend on gaming and so forth. If you look at gaming in general, gaming is down. There are casinos that are struggling. The industry that supplies them with technology, slot machines, this type of thing, they're down. It's all down. And to think this would even be viable in this economy is somewhat surprising. We have two administrations, the past Bush administration, now the Obama administration, who seem to have very little interest in furthering this. So it's not to make a value judgment about is it a good thing or is it a bad thing. It's just to look at it through the lens of where we are now in 2011, not the lens that existed in 2005 or 2006. The idea of the property value Supervisor Rose brought up is very interesting as well. As long as there's an option on that piece of land, no one is going to come forward and propose buying it, developing it, renovating it, turning it into anything than it is. Does it have intrinsic value, that piece of property? Sure. Located right along I-94. Another piece of property just farther to the south, Highway 50 in 94, was the site of the old Howard Johnson's. Someone thinks enough of that property to purchase it for $2 million and torn it down. They're just sitting, they're waiting for someone to come along, invest some money into it because they know it has intrinsic value. So that property's ripe, that's ready to go, and you'll see that be developed when the time is right. It's in the wings. This property is not in the wings, it's on hold, and the more we delay and procrastinate, 90 days, 30 days, whatever have you, I think we're just delaying the inevitable that this is not a viable project. So therefore, I would not be in support of the current proposition. Thank you.
Thank you, Supervisor Grady. Supervisor Brunig, I believe you're the last one.
Thank you, Mr. Chairman. I apologize also for being late. I was up in Madison today, and I wasn't expected to return except for an emergency at home. I have a few things I would like to say. First of all, regarding Plan B from the Common Council, I did have a discussion with the President of the Common Council, and there's no Plan B at this time. They've not considered anything. We sat here a few years ago, and at the last minute, went over an extension for the IGA. At that time, several of the board members were in concurrence. We didn't like doing this. Now here we are sitting here again at the last minute, trying to decide whether or not we're going to extend it 30 or 90 days. I am not in favor of either one, to be honest. But if we are going to, I would suggest that we put a date on this of when they must return. Whether it's the 30 days, they should be back here on April 19th, and if it's the 90 days, they should be back here on June 7th, and that should be it. If you give them the whole entire time, this one that says April 30th, by April 30th, or prior to April 30th, they could come in that night and then expect us to have another emergency meeting. I don't want to do this again, and that's just my opinion. Thank you.
Thank you. Seeing no other lights, before us is the resolution as amended. The only amendment before you, what's that? That's what I was saying. Before you is the resolution as amended, and the only amendment is going from 30 days to 90 days. Any questions on what the vote is going to be? It'll be the resolution on the amendment. I see why Frank's questioning me. It's on the amendment, which is 30 days to 90 days. Roll call requested. If you're in favor of the amendment of 90 days in lieu of 30, P and plus. If you're opposed, P and minus. It's all the same thing. Correct, correct. That's all of us. Motion carries 21-4. So before you now is the resolution as amended. Just, well, they only have the blue document, so they're good. Before you is the resolution as amended, which is a 90-day extension. Roll call vote. If you're in favor of the resolution as amended, P and plus. If you're opposed, P and minus. Motion carries 21-4. Motion adjourned by Supervisor Elverman, seconded by Supervisor Singer. All those in favor signify by saying aye. Aye. Motion carries. We're adjourned. We'll call the meeting to order. Special County Board meeting, Tuesday the 29th. If you'll please join me in the Pledge of Allegiance. Thank you. Pledge allegiance to the flag. Roll call of supervisors. One more. How am I going to figure out who's missing? There we go. 25 in attendance. Citizen comments. Anyone wishing to address the board? You'll have 5 minutes to address the county board. Anyone wishing to address the board? Yes, ma'am. Name and address.
My name is Lori Bovine. I reside at N2840 State Highway 55, Kenosha, Wisconsin. I would just like to take the time to thank the county board for approving the extension under committee and for doing it as a 90-day. Again, I know it was short notice, but we really appreciate you hearing us tonight and taking those votes. So thank you.
Thank you. Anyone else wishing to address the board? Seeing no other citizens, citizen comments is closed. Clerk
Discussion, consideration, and possible action on a resolution to extend the term of the intergovernmental agreement pertaining to the development of casino in Kenosha entered into on March 28, 2005 between the Menominee Indian Tribe of Wisconsin, the Menominee Kenosha Gaming Authority, the City of Kenosha, and the County of Kenosha, and the intergovernmental agreement between the County of Kenosha and the Menominee Indian Tribe of Wisconsin and the Menominee Kenosha Gaming Authority regarding sales tax, and the intergovernmental agreement between the City of Kenosha and the County of Kenosha relating to revenue sharing executed on March 28, 2005.
I will entertain a motion from the floor. Supervisor Singer.
I'd like to, I don't know what the number is, if we haven't numbered it,
Don't have a number yet.
but I'd like to move the resolution to approve the extension for the Menominee.
Moved by Supervisor Singer, seconded by Supervisor Elverman. Supervisor Singer.
As we've discussed in this, I think it's the economically best thing to do. I think it's, as a representative way, I think it's, we're representing the people of Kenosha County on how they voted. I believe last time it was even a bigger percentage than it was the previous time. And I would just approve, or like everybody's support on this if it's possible. I understand that where we're at. Thank you very much.
Thank you. Supervisor O'Day.
Call the question.
Motion to call the question by Supervisor O'Day, second by Supervisor Johnson, is that right?
Johnson.
On the issue of calling the question, all those in favor signify by saying roll call is requested. If you're in favor of calling the question, P and plus. If you're opposed, P and minus. One more. Double check your buttons, please. Supervisor. Thank you. Motion to call the question carries 20 to 5. Motion was made by Supervisor O'Day, seconded by Supervisor Johnson. All right, before you then is the resolution to extend the intergovernmental agreement 90 days. Roll call is requested. In favor of the extension, P and plus, opposed, P and minus. Motion carries. Imagine that, 21 to 4. Entertain a motion to adjourn. Motion adjourned by Supervisor Michael, seconded by Supervisor Arrington. All those in favor signify by saying aye. Aye. All those opposed, we're adjourned. Thank you. I appreciate you meeting tonight. For those of you who are in support of the resolution, I have the original up here. You need to come up and sign it, please.